read a bit about. And I suppose in the time that we have together tonight, we are just going to unpack some of it. As will become clear through the webinar, there is a lot of detail in the pact, much more than an hour could get us through. So we're just going to really give you a bit of a broad overview and hopefully whet your appetite to go and do a little bit more research yourself and focus on some of the aspects that are related to both Sarah's research and my research. So hopefully the slide has moved on, I'm hoping. The plan for tonight is, first of all, in a few moments, I'm going to hand back to Sarah, who's going to give us a bit of a context, sort of what's come before the pact and what will come, you know, what will come around it, the context. And then I will talk a little bit about the pact itself after we've got that context. And then we're going to move to two different areas that are related to our own research. So Sarah is going to talk about solidarity in the pact and in the EU asylum system as a whole. And I am going to talk about addressing trafficking in the pact, or perhaps more accurately, the lack of addressing trafficking in the pact. And then there will be some time for questions and answers. So that's really the plan. I'm going to hand over to Sarah to give us a bit of context. So over to you, Sarah.
That's great, thanks. Yeah, so if I could just go to like the first slide of mine, if we can.
I'm assuming you can't see that right now.
No, sorry.
So maybe I'm doing the wrong thing.
It's okay. What I'll do is I'll just sort of speak around it, and if the slides come on, then that's absolutely fine. It's only really to give an overview of what I'm talking about. Actually, I see them now anyway. So what I thought would be really useful before we look to the new EU Pact more specifically, and to draw out some of the thematic areas of concern, was to ensure that we have an understanding of the context in which it was essentially developed. So the formation of a common European asylum system, or CEAS, is a continuing work in progress since the adoption of the Tampere conclusions in 1999 by the European Council. And it essentially establishes a complex legislative framework for protection obligations, really, in respect of third country nationals seeking asylum. And as I've noticed on the slide, it ultimately originated from the desire to really counterbalance the elimination of intra-EU borders under the Schengen agreements. And it really is arguable that really the common European asylum system is really the product of both political compromise and attempts to then explicitly securitize external borders within the asylum context. So the elimination of internal borders really brought to the fore a shared concern by states regarding border security. And it really required then as such really compensatory measures in place. And as Gillian will speak to later on, these tensions have not really dissolved since the origin of this whole process. So the multifaceted legislative mechanisms of the common European asylum system, that I've put some of them up on the screen there for you now, it really ensures that reaching the EU is only the first step for persons seeking asylum or seeking protection. And whilst attempts had stalled over securing the recasting of some of those instruments noted in the PowerPoint, it is worthwhile noting, I think, as well, that the European Border and Coast Guard Agency, so Frontex, has most recently secured a further reaching mandate on border and migration control last year. So persons in search of protection must not only overcome really dangerous journeys, dangerous crossings to reach the EU, but they must also overcome a system constrained by policy tensions from member states and the EU itself regarding admission. So really think about this idea of Fortress Europe as well. And it is arguably now more than ever the leading approach really that has been taken by states aiming to externalize irregular migration practices and really adopt insular policies in response. So border and sovereignty arguments are therefore becoming really an ever-present feature of the migration policy landscape. So the competing tensions between borders and sovereignty on the one hand and effective protection and solidarity on the other are really the source of these competing interests at play. And they have been for numerous years. It's not something that is completely new just with this pact. So I want to move on now to the next slide and just really speak about the growing issues more generally. So what I really wanted to highlight within this slide is sort of the enormity of the issue on the global scale, and really to put that into perspective. The EU policy responses at the height of the refugee crisis had always really been linked to this crisis rhetoric, that it was simply an issue of the volume of persons, and that the legislative framework was really, in essence, only temporarily experiencing difficulty. However, as the months and years which followed highlighted, and as many refugee experts in this area will be aware, this was simply not the case. Rather, this sort of crisis rhetoric was fueling attempts and efforts really to disguise the legislative and operational shortcomings of the common European asylum system itself. So if we move on to the next slide, then we'll have a look at this crisis of protection and solidarity. So really, on closer inspection, it is also worthwhile evaluating whether the EU was or is experiencing difficulty with the number of persons in absolute terms or pure absolute terms, or rather, was the harmonised legislation and policy decisions by states, and to varying degrees, something which contributed to an inequitable distribution of the claims amongst EU member states and also externally as well. And that latter point is of particular relevance if you look to the PowerPoint and note that 85% of the world's refugee population are situated in developing countries. So as such, rhetoric focused on the management of really an EU-wide refugee crisis also needs to be put in into this global solidarity context. So two final points before I hand over, and that I think appear significant when looking at statistical asylum data in this area, and just as I've noted it. Firstly, that numbers and statistics are really invaluable to analysing trends and the impact on legislation. And this is what an academic, Alice Edwards, has referred to as a numbers game. But secondly, and really conceivably intertwined, is that we also need to look beyond the numbers, recognising that each number or each statistic speaks to the broader sense of really a lack of humanity that has come to encompass refugee protection. And as I will be looking at in my sort of second section, the lack of solidarity and even the shifting of responsibility between states for protection, it really is this numbers game and also a humanity game. So solidarity, or lack thereof, speaks to really how far states are willing and capable of providing for persons seeking international protection. And that really comes into play a lot when we look at the EU Pact. So I'll pass now over to Gillian, and Gillian will speak to the overarching specifics of the Pact, and then we'll draw out two themes that are really based on our own research. So thank you very much.
Thanks, Sarah, and thanks everyone for bearing with me while I got the slides sorted. I think we're there now. So just with that bit of context, which has really been shown, you know, that this pact doesn't come in a vacuum. This pact is the continuation of something else. I just want to move on then and look at the pact and where we're at now. So on the 23rd of September 2020, the pact was put forth, and you know, we hear a lot of people talk about the pact, but really I suppose the question is, what is this pact? Obviously it's a continuation of a lot of stuff, and maybe where there had been clashes before, or in the sense of differing states with differing views, and as Sarah has pointed out, you know, these sort of this crisis rhetoric, and really the pact, I would say, is less of a pact and more of a package of various different proposals, legislative proposals, and also non-legislative proposals. The EU Commission has framed the pact as a fresh start, And that really has been questioned. Is it a fresh start? And Steve Pearce, who is a professor of EU law, when he's been writing about the Pact, he said that it's really less of a complete restart of EU law in this area, and more of an attempt to relaunch discussions on a blocked set of amendments to that law. And I think we have to see this Pact in this overall context, which Sarah has just described for us, this kind of tension between solidarity and humanity and all that goes with it. That's what we're looking at when we look at the Pact. So is it a fresh start? Possibly. The Commission's webpage, we read, based on a holistic assessment, the Commission is proposing a fresh start on migration, building confidence through more effective procedures and striking a new balance between responsibility and solidarity. Now, it all sounds very positive, sounds very promising, but I think if you look past that to a lot of the commentary on the Pact, both from journalistic, NGO and academic sources, that optimism and that positive language is certainly questioned. And it does make us wonder if it is simply rhetoric, this idea of a fresh start and a balance between responsibility and all of this stuff. Charlotte, who I think is in this webinar, had written a blog for the Network for Migration Matters, and I thought her title was very interesting about the Pact, which was "The more that things change, the more they stay the same." And I think there's something very telling in that. I think that sums up a lot of maybe the opinion sort of in academia and practice about this Pact. But that being said, there are some things that have changed, and I do think it's worth having a little look at those. Whether they've changed for the good or not, that is another question. But essentially, the Pact is a package of various proposals and instruments on things like screening, asylum procedures, this concept of flexible solidarity, which we'll come to in a few moments. Also, crisis preparedness, so preparing for crisis or perceived crisis. And then search and rescue. So a lot of you will be aware that there have been some criminalisations of search and rescue vessels in various EU countries. So it is good to see that being dealt with. And so when I talk about this package, essentially there's 9 parts of it. That's why we're definitely not going to go through all of it tonight, or we'll never be going. But there are essentially 9 different aspects of the Pact. They are between legislative and non-legislative instruments. And I'm aware that maybe not everyone here is necessarily from a legal background. So I think it's worth clarifying the difference between those two. So legislative instruments are legally binding, and they've been created through a legislative process, and you know, have a stronger binding force. Other instruments are recommendations, guidance, that kind of thing. So they wouldn't be binding. They are more guidance and recommendations. So it's good to see them there, but it's worth noting that they don't have the same sort of force as the top category here. And that is important when we look at the content of these as well. So we have in the legislative instruments, and the couple that I've put in bold here is because I'll focus on them a bit more. So we have a screening regulation. That's new. For any of you who know a little bit about EU asylum procedure, that's completely new. So we'll come back to that in a moment. There's also amended Asylum Procedures Directive and the amended Eurodac regulations. So again, Eurodac is about fingerprinting. It's about checking details if there's been a hit. I'm sure you've heard of that before in this sort of asylum context, the idea of if someone has shown up in another country or they show a security risk. So that's what that's about. Then we have the Asylum and Migration Management Regulation. Now, for those of you who are familiar with the Dublin system and the Dublin regulation, it's proposed that this regulation will replace the Dublin regulation. So that appears to be quite significant. Perhaps when we look inside it, we'll see that not that much has changed, although there are some notable changes, which again, we'll come to in a minute. And then there's a crisis and force majeure regulation. So that's the main legislative aspects of the Pact. Other measures we can see down here, and I'd like to draw your attention to 2 of them, the recommendation on search and rescue and the recommendation on resettlement and complementary pathways. to me, at least in my opinion, I think those getting in there are two of the most positive things that could have come in this pact, and acknowledgement and just this recommendation. Resettlement and complementary pathways, for those who aren't familiar, this is really to do with safe and legal routes to asylum, which are very much lacking. So any attention given to that really, I think, is to be applauded, as is a recommendation of just even that protection of those who are conducting search and rescue. Private vessels, you know, this idea that they should not be criminalized and they should not be punished for engaging in those activities. Why I made the distinction earlier between legislative and non-legislative instruments is you'll see that these two haven't quite made it into this. They are still recommendations, and I think that probably demonstrates something about maybe how they're slightly more controversial or slightly less palatable for you know, to reach consensus among member states. Which shows that there is still more work to be done. But I think anybody who's interested in engaging in advocacy on these issues, I think those are two instruments that, you know, you absolutely I would recommend, you know, getting your head around, and also, you know, engaging in advocacy over those, because it is, if nothing else, a good start that they are in there, and that attention is being given, and that more thought is being given to things like resettlement, complementary pathways, and search and rescue. So the two that I want to focus on, the screening regulation, which is new, and the asylum and migration management regulation. Well, the screening regulation, what does it do? Well, it proposes a number of things, and essentially, if passed, this regulation will require that those who enter an EU member state irregularly or illegally, or those who are disembarking a search and rescue, will enter a screening process that will take a number of days. And in that screening process, and during that time, you can, I hope I'm conveying this correctly, but my understanding is that those individuals will not be considered to be legally within the territory of that member state. And that has important sort of ramifications, let's say. During that time, there will be a security check, there will be a health check, and there will be a vulnerability check. And with all of those checks, then after all of that, it will be decided which asylum procedure that an individual will go through. So whether it will be what's called a border procedure, or whether it will be the normal asylum procedure. So that is essentially new, if that would come into play. Now, what does all of that mean? Well, essentially, those who would go through the border procedure, which I suppose is thought that it would not take as long and will be a little bit expedited, will be people who are considered to be a security risk. There will also be people who, I can't remember the exact percentage, but who essentially come from countries that would be deemed to be safer or have a lower chance of getting an asylum claim accepted. So essentially, from that screening, the idea is that those who it's thought that they would not have that much chance of a successful asylum claim, they'll go through the border procedure. And others will go through the normal procedure. I think one positive aspect to note is that unaccompanied minors will always go through the normal procedure. So it is good to see that protection there. There are also a number of provisions in that regulation about fundamental rights. And I think that's really important. But I would say, just given some of the concerns about it, which we'll get to in the trafficking section, I think, again, those who are engaged in advocacy and research, I think, really ought to pay attention to those requirements for fundamental rights to be considered, because there are a lot of concerns, especially with, like, again, Steve Pearce has pointed out, you know, these sort of restricted appeal rights, in particular with the border procedures, and then also with removals, this idea of removing quite quickly after a decision has been rejected. So lots of new stuff there in the screening regulation, really lots to look into if it's something, you know, that is that you're looking into, the whole area of asylum in the EU, and sort of the implications of what that would mean for asylum procedure, and this idea of screening and border procedures, and also this idea you know, of expedited procedures and all that kind of stuff. So that's the screening regulation, and that's really the part of that. There's also then the other one I wanted to focus on, the asylum and migration management regulation. So this is really about allocating responsibility and provisions on solidarity. As I say, for those who are familiar with Dublin, this is going to replace the Dublin regulation. On solidarity, essentially, and again, this is really, I don't want to stray too far into Sarah's fields, but this is really to do with sharing the responsibility. And in this regulation, it is proposed that member states could get involved in solidarity through relocation, but also through, I think it's called return sponsorship. And essentially that is sort of providing money to help with return and removals for those who had unsuccessful claims. So obviously that has proved to be rather controversial for a number of reasons. So solidarity is dealt with there. There's also some mandatory solidarity provisions in that regulation as well. But as well as that, this regulation will decide, how the country that's going to deal with an asylum claim is allocated. So I'm sure a number of you have heard of this kind of first safe country concept, which in some ways permeates the Dublin regulation, although it is not recognised in international law, and it's also just not quite as straightforward as sometimes it's called within the Dublin regulation. Same in the Asylum Immigration Management, this new regulation. Essentially, family ties and family links still have a role to play, in particular for unaccompanied minors, which is encouraging, and I think that's something that's good to see that will continue. Also, the best interests of the child are taken into consideration. For adults, obviously, family ties can be important in allocating responsibility. There's also a new criteria which is to do with if someone has achieved a higher education diploma in a certain country, they could also have a claim accepted there, which again is promising to show that genuine links are sort of being looked at. But I think it remains to be seen how many people could in practice benefit from that. And obviously there are some other criteria, but essentially this is about allocating responsibility. I think one thing to draw your attention to in this new proposed regulation is that asylum seekers will have an obligation under this to apply in the first country they arrive in, and then obviously responsibility will be decided based on these criteria. And the consequence of non-compliance is a sort of limited application of the Reception Conditions Directive and the protections in that. So I think that is also something to maybe put a bit of a red flag at and have a think about. Yeah, just the implications of that in practice. So I don't want to spend all night going through each instrument, you'll be pleased to know, but those are just two, I think, of probably the more talked about or discussed aspects of the Pact. So hopefully that's given you a flavour for the kind of things that the Pact is trying to do, and also a little bit when we look into this Asylum Immigration Management Regulation, that actually it is quite similar to Dublin, and there is that kind of things are staying the same a little bit as well. So just before I hand back to Sarah, I'm not going to go too much into it, and I was actually going to show you how to track the progress of these laws online, but I don't want to mess with the screen sharing, so I'm not going to be that ambitious. Well, I'll point that out at the end. I just copied a couple of pictures from the Commission's website just to show that, really the Commission is very positive about this. There's this idea of like stronger trust, well-managed borders, effective solidarity, and you can see that goes right through even how the screening and these faster procedures. So there's certainly a lot of optimism from the EU side about this, but there is cause for concern as well beyond that. As for a roadmap of where we are, this is just one page of the roadmap, but it just shows that you can see down the side, like Q3 of 2020, which is where we are. And then the sort of, they are hoping to roll a lot of this out within the next year or so. So you can see Q1 in 2021, there's some things happening. Q4 in 2020, some things happening. And the screening regulation and migration management regulation, which I've just talked about there, both been through a first reading in the Parliament. So, they are at quite an advanced stage in the process. So it's just, I think, also useful to know where we are in all of this, that it wasn't just that the Pact came and that was that, but that these are ongoing processes of committee stages and approvals. So that is really sort of a very fast tour through the pact and what it contains. And now I'm going to hand over to Sarah, who's going to talk a little bit about solidarity in particular.
Thanks very much, Gillian. That was a great analysis of the EU Migration Pact. There's obviously an awful lot to deal with, so I think it was good that you distilled it down into sort of the little sections. Okay, so I'm going to look really at solidarity and I suppose what does that really mean in the refugee and migration context. So really the often elusive nature of states working collectively to respond and share responsibility for the world's refugee population has really been a long and a core concern for the international community. The dominant narrative by states, by politicians, general society is that refugees are a cost. So a cost economically, a cost socially, and also possibly a cost politically. In essence, really, they see them as like a burden to be shifted or avoided, yet rarely ever shared. So how states allocate responsibility for protection is a really contentious and complex issue within itself, no more so really than within the EU's regional legislative framework of the Common European Asylum System. So like I said, it's a really contentious issue, specifically over the last couple of years following the increased number of arrivals of persons seeking international protection within EU territory. So despite this as well, the Common European Asylum System is really at a critical juncture in terms of compliance. Numerous interpretations and really fluctuating understandings of what solidarity actually means or it actually entails often combine in sort of superficial pronouncements and wavering commitments in actual practice. And that can be seen by some of these statements that have been made over the years, the most recent in the State of the Union address. So really step in the new Pact on Migration and Asylum. What we are really seeing is a renewed effort to focus the solidarity debate within this new package of reforms. The question that remains is whether this simply reinforces the status quo or it actually builds towards some kind of substantive change in policy. So declarations of solidarity have, like I've noted, emerged most notably in recent years. And it's really been sort of deemed to be the essential component or glue with which to salvage this harmonisation process of the EU with regards to asylum policy. Solidarity at the regional level and also feeding into discussions more broadly at the global level appears an obvious necessity to many. And yet it really is this area that is encapsulated most by stagnation and superficial rhetoric, really. And it is often guised by grand and sporadic pronouncements of intent, but it is yet to really be borne out properly in practice. So if we maybe move on to the next slide to look at what solidarity means in the EU context, the EU asylum context. So what is unique within the EU asylum context is that the EU regional model for the first time provides in primary EU law an obligation that law and policy within the EU asylum acquis must be based on the principles of solidarity and the fair sharing of responsibility. With the coming into force of the Treaty of Lisbon then, the EU has committed itself under Article 80 of the Treaty of the Functioning of the European Union to an asylum policy based on these principles. And for the purposes of the talk today, we're really interested in how the terms solidarity and the fair sharing of responsibility are not only defined, but if or how they can be, I suppose, manifested in the current, how they are manifested in the current Common European Asylum System legislation, and also the reform proposals really within the Pact itself. So while solidarity in the EU context is very much focused on the relationship between states, it does not necessarily need to really function in a vacuum of isolation. Interstate solidarity can have ripple effects onto, in this instance, persons seeking international protection, but within the EU asylum context, solidarity is seen between the member states. So should solidarity become a tangible reality between the states in question, in place of really the strained relationships currently at play, refugees seeking protection within EU territory might face an entirely different set of circumstances. So interstate solidarity is sort of as envisaged within the common European asylum system, in combination with responsibility sharing mechanisms, would in theory create less incentives for state to possibly cut the level of protection afforded to persons that are seeking international protection. It all sounds very ideal, but what are we currently dealing with? So we now look to the Dublin 3 regulation. So the Dublin system of allocation, as Gillian actually had already alluded to and noted, it was initially established as the 1990 Dublin Convention, and it's currently structured under the Dublin 3 regulation. So it had a predecessor. And it ultimately determines the member state responsible for the processing of asylum claims within the broader common European asylum system framework. So the Dublin 3 regulation, now in the second phase of recasting, came into force in 2013, and very much similar to Dublin 2, it applies to all the 28 EU member states and also the 4 non-EU states associated with the Schengen and Dublin system. So Iceland, Liechtenstein, Norway, and Switzerland. You can insert your own Brexit joke here about the EU 28. And it was formed primarily to prevent multiple asylum claims or secondary movement in multiple member states. Otherwise, it was colloquially known as asylum shopping. So the Dublin system of allocation sets forth a hierarchy of criteria to determine which member state is therefore responsible. So although renowned for the principle which sends an asylum seeker back to the first state of entry within the EU, effectively the Dublin system rationale attempts to send asylum seekers back to where the principal influx is taking place, and ultimately where sort of human rights protection within the asylum system is most under strain. And it's therefore not really surprising that the courts have been tasked with remedying breaches or potential breaches of human rights for applicants subject to the Dublin transfer procedure. So next, I really want to look at the intra-EU relocation decisions. And that was sort of another element really that was brought in prior to the EU Migration Pact. So notably, the relocation decisions were adopted on the legal basis of Article 78, subsection 3 of the Treaty of the Functioning of the European Union. Essentially, this is sort of emergency solidarity in light of the increasing arrivals of asylum seekers to EU territory and largely to frontline member states. And the decision activated a provisional, so it was 2-year, unlimited derogation from the allocation of responsibility for examining asylum claims, really that's set forth in the Dublin 3 provisions. In other words, asylum claims whom Greece or Italy would ordinarily be responsible for processing. However, Grand Chamber judgment on September 2017 was really eagerly anticipated by many. And it marked an important contribution to the regional debate on solidarity amongst EU member states. And in this decision, the court dismissed attempts by the Slovak Republic and Hungary to annul the second of the 2 relocation decisions. And the specifics of that was because it provided for the second of the relocation decisions provided for the mandatory emergency relocation quotas for asylum seekers. The first relocation decision didn't have a mandatory quota. And really the fact that such a case is before the court really epitomizes the unfortunate yet, I suppose, harsh reality that particular EU member states are simply unwilling to contribute to a model of protection that really imagines solidarity and the fair sharing of responsibility as a byproduct at its core. Okay, so really then the question is whether can relocation be seen as a concrete illustration of solidarity and the fair sharing of responsibility, which the EU Pact on Migration aims to achieve. So if we now move on to solidarity in the EU Pact on Migration and Asylum itself. So the promotion of solidarity is really the core tenet of the overarching reform proposal within the EU Pact. So what is really being proposed within the Pact itself? Well, essentially, the Dublin 4 proposal, which was already tabled, has essentially been scrapped, and a proposal has been made to develop a new solidarity mechanism, is what they're rephrasing it as. And that is to replace the current Dublin 3 regulation. And this is the proposal for an asylum and migration management regulation. So you'd be forgiven in thinking that this is probably a new shiny reform package, and yet it is really essentially a patchwork of the old Dublin 3 regulation, or what is currently in force now, some proposals which had already been made for Dublin 4, and some additional amendments all bundled up in sort of this new document as such. However, one specific element I do wish to focus on is the solidarity mechanism which introduced. And what essentially is that? So essentially the Commission will determine on a yearly basis whether a state is essentially overwhelmed with arrivals, and a support package, I think it's framed as, really to help alleviate this through a range of relocation and other contributions. As ever, the actual workings of this are really as complex as can be envisaged. But it essentially distills down to the fact that member states can then notify the Commission should they wish to offer any contributions with regards to this. All well and good, you might think. Well, yes, I suppose. But should enough states act in solidarity, what happens is that it's referred to as a solidarity pool is formed. And once the under pressure state activates it, then relocations can really start taking place from that under pressure state. However, if the contributions by the member states fall 30%, I believe, short of what the Commission deems necessary in terms of relocation, then essentially the Commission does step in, and it's what is termed as a mass correction mechanism. And this mode then, a mandatory quota is determined for the member states. Yet, ironically, they will be allowed to actually discharge their relocation duties should they wish to, and what Gillian had actually referred to at the start by offering return sponsorships. In other words, they aim to return the person seeking international protection, and only should that either fail or go beyond a set time limit, then they have to accept the person. So it's really sort of they're acting in solidarity by forcing removals as such. So really it all appears very, well, to me at least, very bureaucratic, lengthy, and essentially a very, very complex process. One point I would just really like to make, without going into really the more specifics, but just a broader reflection, is that it reads entirely on the assumption that we see asylum seekers as transferable objects by the legislation and politicians alike. The entire system is framed whereby persons seeking international protection are assumed to be as easily transferable as, you know, a monetary transaction, a situation which we know is clearly not, or more specifically should not be the case. I will leave it there, but just to sum up, the new proposals really do create a highly complex and burdensome system. The question that remains is whether this will be enough to entice a sufficient level of states to agree really to these proposals, unlike really the deadlocked prior proposals that were in force. But I'll hand over to Gillian now for the final section. Thank you.
Thanks very much, Sarah, and thanks for being a trooper and just going on through all of that and without the slides. Really interesting stuff, and Sarah's research, for those of you who don't know, focuses quite a lot on solidarity in the EU, so it's really a treat to hear you discuss it. So I am now gonna, and I'm just aware in time, so I don't want to spend too long on this, but just another aspect of the pact that I wanted to focus on was the human trafficking and the pact, or the absence of human trafficking in the pact. And really, I know that it might not be sort of the first thing that you think of when you think of the pact, you know, where are the provisions on human trafficking? But I really think it should be a consideration, and I think it's really something that needs to change across asylum law and policy in general, beyond the pact. It is that it's not always an explicit consideration. Before I do that, just very, very briefly, what is human trafficking? It's defined in Article 3 of an instrument called the Palermo Protocol. Essentially, there are 3 elements: an act, a means, and a purpose. And if you have those 3 elements, you will have a situation of trafficking. Now, where does migration come into this? I know that trafficking is often thought of as something that involves migration. In fact, it is not. Migration is not a requisite for trafficking. As you can see with some of these acts, you've got things like recruitment, harbouring, and those don't, you know, by definition require migration. However, certainly in my own research, I would consider migration, or more accurately, certain kinds of migration, let's say risky migration, such as migration for asylum or smuggling, to be kinds of migration that increase trafficking risk. And I think that's really where we have our nexus between migration and asylum and trafficking. And states have a number of obligations to address trafficking. And I would certainly argue that if states want to be serious about their sort of pursuit to end human trafficking, as we often hear, or fight human trafficking, then the responses need to be able to function in the asylum context, in other contexts too, but most definitely in the asylum context, both on the journey, but also within the asylum process, and where that risk remains. And all that being said, why? Well, states have obligations to address trafficking, not just to criminalise trafficking as we often think, but beyond criminalisation, states have obligations. I've just thrown up the Palermo Protocol and the EU Trafficking Directive. Palermo, most, if not all, EU member states are parties to that. And here we see that they have an obligation, not just to criminalise, but to establish policies, programmes and other measures to prevent trafficking, and also to protect people from being re-trafficked. They also see similar obligation in the EU Trafficking Directive. So states don't only have to criminalise trafficking and prosecute trafficking, but states have obligations in international and EU law to prevent trafficking. And I think, you know, policies, measures, other measures, you know, that's a proactive obligation. You could almost argue that's an obligation of due diligence, but it's certainly an obligation where states have to do something. And I would argue that, you know, in other areas where there's trafficking risk, I think there is an obligation there to do something and to have that foresight in trafficking. At the very least, I think states, when they're designing other law and policy in other areas, certainly shouldn't have laws that aggravate trafficking risk, I think, at the very least. And that is where my concerns would be in the pact, and that lack of an explicit connection. So if we look just briefly again at the 2 instruments that I discussed earlier, Asylum and Migration Management Regulation proposal. I did a sort of Control and F word search through the 118 pages of the proposal, and I found only 2 mentions of human trafficking. And I think that in itself is telling. The connection is just not there, whether that's intentional or whether that's just from a lack of sort of that connection being made, or that the necessity of that connection. It's hard to know. Both are in the context of unaccompanied minors, and I do welcome that attention, but I think it needs to go much further than that. And the trafficking, the risk of trafficking, or just attention to reducing risk of trafficking and training, you know, it would be good if we could see that in legislation, explicit obligations to consider even future trafficking risk in removal decisions. And I think in particular when we see that there are these border procedures and stuff, so if we look down to the screening regulation proposal, perhaps a little more promising. Trafficking was mentioned more than twice, I think 8 times. But yeah, in the proposed Article 6, There is the involvement of national anti-trafficking rapporteurs in this screening that I talked about, where appropriate. But I think even this sort of qualified language of where appropriate, and then, you know, beyond the explicit mentions of trafficking, are there elements in these instruments in the Pact that actually aggravate trafficking risk? So things like this responsible state and solidarity and treating, as Sarah was saying, treating individuals like objects to be moved around. You know, is this putting people at more risk and sort of increasing desperation? Stronger borders, border procedures, screening, not allowed to be in the territory, you know, removal decisions, reduced appeal rights, all of these things. I think we need to ask questions, not just about compliance with international refugee law, but compliance with other areas of international law. And I think a strong one for that, to create a challenge to some of these protection obligations, are the obligations that states have under trafficking law. So I think there's a lot to be said there, you know, and I think, you know, these regulations haven't been introduced into law yet. So it'll be interesting to see. I mean, they are at a fairly late stage in the proceedings, but, you know, even if this is an area that you're interested in, I do think there is room for engagement, and there's room for raising these points and challenging states and challenging the EU institutions on, you know, the content of these, and even in future iterations of these, you know, and reminding them of their obligations to address trafficking, which states are often very happy to discuss and promote what they're doing. So that's really just a quick whistle stop tour through, you know, trafficking in the Pact, or maybe to draw your attention to the lack of the attention to trafficking and the implications on that for asylum seekers. That, you know, those who are seeking asylum are vulnerable just by their very nature of having to flee their country, and they are people that we owe obligations to. And in the midst of all of these procedures, just like human rights need to be protected, I think we need to remember that we shouldn't be placing them at greater risk. They shouldn't be falling into greater risk in a context where they are owed protections. And I think the trafficking problem highlights that very well, just this aggravated risk, and yeah, just the obligations of states to do something about that. So I think that's another lens through which we can look at some of these aspects of the Pact, which just through looking at that one protection lens can actually highlight other protection problems. So just very, very quickly, because I know time is marching on, what now? Well, I wanted to end by sort of saying, you know, what do we do with all this? You've just heard us speak for quite some time about all these laws and all these provisions, but what really can we do practically leaving from here? Well, you know, go on the EU Commission website, go on your links. I didn't actually show you, but you can actually track EU law, type some of these in, look at what stage they're at. You can see what committee stage they're at. You can see the rapporteur on the parliamentary committee. Write to them, ask them what they're doing to, you know, to ensure protections are in these. You know, these aren't passed yet. I know they are obviously at a fairly advanced stage, but still continue this conversation. NGOs, if you're part of NGOs or advocacy groups, you know, continue to find ways to hold states to account on the rights obligations they have agreed to in this Pact, and continue to raise them, and essentially just join the conversation like you're doing here now. Find out, you know, what's going on, be informed, and participate in the conversation at any level, I would say. So like being here tonight, the first step, and, you know, go away, have a look, dive in more into this, and find a way to join the conversation. So I don't want to go on further because I know we're running out of time, so I'm going to end there. I'm going to hand back to Imogen for some Q&A.
Thank you very much, Gillian and Sarah, and thank you all for your patience. I know that was a little bit unexpected, but I suppose it highlights that these conversations are really important, and unfortunately there are some people out there who are not necessarily receptive to them. But in any case, I'm going to open the floor to any questions. So if you have any questions, please pop them in the chat and we will ask Gillian and Sarah. I'll kick us off with one, I suppose, quite simple question while people are writing theirs and submitting them. And that is really, how long do you think it will take for all the elements of the Pact to really come to fruition? Big question. Do you want to take this one away?
Yeah, I mean, I don't know. I think, you know, how long is a piece of string is probably how I would say that. If you look at the roadmap, it's very ambitious in terms of sort of the next 1 to 2 years. But if you then look at sort of, you know, the recasts or the sort of, you know, proposed Dublin 4 and all that kind of stuff that never came about, and they're still waiting for it, that puts a different slant on it. So I'm not sure. Sarah, do you have some thoughts on that?
Yeah, I mean, obviously there's just going to be, it's what states are willing to allow for, really, and whether they will actually even allow it in its current form as it is, or there's maybe still going to be some stumbling blocks. You know, parts of the issues that I had brought up about the solidarity issues, I don't think that hasn't dissipated in any way. You know, there were still the states that were not willing to engage with the EU relocation decisions, and they will still be the states that are not willing to engage with solidarity in this type of document either. So yeah, I think probably what we can actually see is that we talk about the common European asylum system, but I suppose the bigger question is it really common at all? You know, that it's got all these harmonized laws and procedures, but states have a very, very different interpretation with regards to that. So that's sort of my cop-out answer, I suppose. But
cop-out answers are welcome. So our next question, our next question is: there are a lot about EU measures. I'm going to say the awful word. What is going to happen with the UK's commitments after Brexit?
Do you want to go first, Gillian, or will I?
No, you take it away, Sarah.
I think really prior to the referendum and the subsequent vote on, I suppose, EU withdrawal, there was this prevailing sense of that the vote was very much largely dominated by viewpoints on immigration control and really the large number of third country nationals attempting really to seek asylum in the UK. You can think back to all those posters, it was taking back control. And yet there really is, I suppose, an ironic twist in the life post-Brexit sort of the situation, because with regards to refugee protection, from a legal standpoint, the UK still continues to be bound by the 1951 Refugee Convention and the 1967 Protocol, and furthermore supplemented by, you know, a vast array of human rights obligations. I think, you know, refugee scholars and people working in this area will undoubtedly sort of really lament the lack of supervision from the Court of Justice. I don't think they get it right all the time, but it's definitely a very proactive court in that regard, and participation within the common European asylum system, not immune to criticism either. The core obligations do remain, and EU withdrawal does not automatically equate to a reduction in refugees and the protection obligations that really follow from this, much as what maybe the Leave side really did try to argue. Really what will happen is that I'd imagine they will have to renegotiate. So they were actually in a very, very good position prior to this. They were able to rely on their negotiated opt-in, opt-out status within the area of freedom, security and justice, especially with regards to the Dublin 3 regulations. So they're actually, UK was in a very, very good position prior to their withdrawal. And I can't imagine that they will be able to renegotiate, well, they can renegotiate a separate opt-in sort of to the Dublin procedures, but they'll sort of have to give up, I imagine, something in return. I can't imagine the way the Brexit negotiation process is going so far that the EU are just going to hand them, you know, access to the Dublin regulation and sort of allowing them to send asylum seekers back to other member states. So that's my view on it. I mean, core protection obligations still stay, and in actual fact, they're sort of losing out on something that the UK actually did benefit from. Asylum seekers didn't benefit from it, but the UK certainly sort of did in that regard. So that's sort of my take on it.
Yeah, absolutely. Just, I mean, I don't really have much to add to that. I think Sarah has covered it all. But just, yeah, again, just to highlight the idea of, you know, taking back control, and I suppose the rhetoric around that, and even as we've seen this year, you know, like channel crossings and a lot about being removed back to France. And I suppose, you know, unless there is this renegotiation of an agreement, obviously, if the Dublin is abolished, it'll be obviously a renegotiation of something a little bit like the Asylum and Migration Management Regulation, but bear in mind that that regulation will come into force when the EU is not a member state, so it won't, you know, by that fact, apply in the UK. So as Sarah said, it's about then renegotiating something else. So actually, you know, in one sense, you could look at it and almost argue that the UK's protection obligations will increase in that sense of, like Sarah said, they won't necessarily just be able to remove individuals back to other countries. I mean, it remains to be seen the outcome of, you know, what agreement on that will be struck. Also in terms of like family reunification and all that kind of stuff. So it's hard to tell, but I think it's important to recall, as Sarah has said, the core obligations still stand. They stand outside of EU law, and they're very, very important. So refugee protection under the 1951 Convention needs to continue.
Great, thank you both for that. It's good to hear that there are going to still be core protections that are applicable, because I know that many of us have been concerned by that. So I think we've got time for one more question, and that is, do other EU institutions have any influence on the EU and its decisions about migration management, for example, the Council of Europe?
Shall I start, Sarah, or?
No, you go ahead.
Yeah, so I suppose maybe even just a little clarification at the beginning that, so the Council of Europe actually is completely separate to the EU. I know it's a bit confusing because we have the European Council and the Council in the EU, but the Council of Europe is the international organisation that would have the European Convention on Human Rights and a number of other really key conventions. I would say that as far as the Council of Europe is concerned, it would be more the European Convention on Human Rights, and the European Court of Human Rights has made some really, really helpful at times decisions on removal, also on sort of Dublin decisions, which you know, where there's been risk of inhumane treatment. Sarah is definitely more expert in those decisions, so I'll let her speak on those. So the Council of Europe, yes. In terms of other EU institutions, I mean, the Parliament, these regulations that are going through at the minute are, you know, the Parliament, they're going through what's called the ordinary legislative procedure, and really the Commission proposes it. Obviously the member states have a role in kind of discussing, but then it's the Parliament and the Council together. It's a sort of joint, it's a little bit different than how legislation would be passed in national states. So it's a sort of joint process. So the Parliament does have a role there, and I think that's, if you're talking about citizen engagement, that's really where you could engage if you are in a EU member state, which I'm aware that a lot of us are now not. You could write to your MEP, and you know, there are ways even for citizens to engage with those institutions. So yeah, Sarah, I don't know if you have anything to add there.
No, nothing much really. So of substance really. It was more just, yeah, the Council of Europe is and has been throughout the years as well, been implementing lots of judgments on migration and asylum matters. So yeah, I mean, I obviously think that the EU institutions and the court itself is very much aware of other decisions sort of internationally and within the broader sort of Council of Europe situation as well. So that might have an influence on it. But as well, probably within the EU, it does sometimes boil down to being very, very technical, and points can sort of feel, or on very, very technical points, maybe not unlike what would happen in the Council of Europe type situation. So yeah, that's all I have to say on that one.
Great, thank you very much for answering those questions and for presenting, of course. And thank you all for coming, most importantly. I hope that you've all learned something from today. I know that there was a lot of information, and of course, this has been recorded. We will be editing the recording to take out a few parts, which we won't say any more about, but we will be editing it. So if you want to re-listen to any of it again, then it will go up on our website in due course. And we will also be writing up a sort of summary of what's been discussed in this webinar as well. So you can read that at your leisure. So for now, I'd like to thank you all for coming, and thank you, Gillian and Sarah, for presenting on what is a very complicated topic and for distilling it so succinctly and clearly for us. So thank you very much, and have a lovely evening or day wherever you are in the world. Thank you.
Thank you so much for having me. Oh, sorry.